Hello everyone and welcome to this short discussion on criminal justice. I'm Dr. Joe Stevens, an Associate Professor of Law at the University of West London. And today I'm going to be diving into a constitutional crossroads, the UK government's new move giving the Justice Secretary, and by extension the Home Secretary, power to veto Sentencing Council guidelines. I'll explore what this means for the separation of powers and the slippery slope of executive influence in judicial realms, and whether these moves address or distract from the deeper systemic issues like racial disparities in sentencing. On the 2nd of September 2025, the government passed a new requirement: no sentencing guidelines can be issued by the Sentencing Council, an independent, if you like, at arm's length body that decide on appropriate sentences, unless it's approved by both the Justice Secretary and the Lady Chief Justice. This wasn't a formal tweak, it follows a serious row. The Council had proposed a guideline urging judges to consider sentencing background factors like ethnicity, religion, gender or age alongside pre-sentence reports for certain groups. They stated the aim was to tackle well-documented disparities in sentencing that we have at present. But critics cried two-tier justice, arguing that singling out minority or vulnerable groups risked undermining equality before the law. So the government intervened, suspending the guidance and moving to legislate to block it. Why should we care about this shift? Well, because it touches the very heart of our democracy. When we look at the separation of powers, the Sentencing Council exists to share judicial discretion responsibly across the system, preventing postcode disparities and ensuring consistency grounded in evidence and logic, not political sentiment. By granting the executive branch, through the Justice Secretary, a veto power over these independent guidelines, we blur that line where policy ends and sentencing guideline begins. Sentencing guidelines are not law-making. Parliament makes laws, the judiciary applies them with informed discretion. This change risks turning an independent advisory body into a political tool, undercutting judicial confidence and independence. So enter populism, when sentencing becomes a battleground for public sentiment or perceived public sentiment rather than legal consistency. This isn't new. Think back to the Venables and Thompson case, the two 10-year-olds who were sentenced for the awful murder of James Bolger. The Home Secretary increased their tariff, disregarding their rehabilitation after public outcry. The House of Lords held it was unlawful. Executive mustn't act on populist pressure, especially in judicial decisions. Similarly, Anthony Anderson challenged the Home Secretary's powers to set minimum terms for life sentences, and in 2002, the Law Lords later the European Court of Human Rights ruled it incompatible with human rights protections. These cases reaffirm executive interference in sentencing can violate the rule of law and the right to a fair trial. The new power over the Sentencing Council may be at odds with that principle. Critics accuse the Sentencing Council guidelines of creating a two-tier system, but let's pause. Do these disparities already exist? The short answer is yes. Data consistently shows that those from black and other ethnic minority defendants face greater likelihood of being stop and search, arrested, and have longer sentences. more frequently involving imprisonment, even when accounting for the same offences. This is not a hypothetical two-tier system. It's real, baked into the operation of the criminal justice system. The council sought to mitigate that gap by ensuring judges had fuller context, not to give preferential treatment, but to inform a fairer decision. The executive backlash risks obscuring the deeper inequalities that are already upon us. The government's latest power draws echoes earlier and debunked approaches. Historically, Home Secretaries set or adjusted minimum terms for life sentences. That changed after cases like Anderson, where it was deemed incompatible with fair trial rights and judicial independence. In another instance, the Home Secretary decided on whole life tariffs and was not bound by parole board recommendations. The McLaughlin-Newell judgments highlight how detached that approach was and why it fell under scrutiny. In Key versus Secretary of State for Justice in 2025, the court reiterated that sentencing decisions, including minimum terms under detention at His Majesty's pleasure, are a matter for the sentencing judge, not the executive. Later changes allow only certain administrative reviews, but the course sentencing remains judicially set. So where does that leave us? We have a serial constitutional concern. An executive veto over independent sentencing guidelines threatens judicial autonomy and risks populist delusion of justice. The two-tier justice framing distracts from existing evidence-based disparities, using that as justification to suppress efforts to improve fairness in sentencing. It's counterintuitive. The lessons of Venables and Thompson and Anderson and the like clearly shows how executive intrusion in sentencing is deeply problematic. Even just advice or guidelines must be shielded from political pressure. Going forward, we need public debate and transparent oversight, not rushed legislation. Parliament should handle sentencing policy through proper legislative channels. The Sentencing Council should stay independent, and the judicial decisions must remain rooted in law and equity, not political optics. Thanks for joining me on this discussion on criminal justice. If you found it insightful, please subscribe, share, and leave a comment on your thoughts. Is this new power a constitutional red line or a necessary check? I'd love to hear your views. Thanks very much.